Welcome to ERA's 30 Years, 30 Cases video podcast. We are highlighting important landmark rulings of the Court of Justice of the European Union, as well as landmark opinions of its Advocate Generals, as part of the celebrations marking the Academy of European Law's 30th anniversary. My name is Ramin Fahrenpool, and I am Senior Lawyer and Course Director in ERA's European Criminal Law section. In this video podcast, we will be looking at the opinion of Advocate General Ruiz Jarabo Colomer from 2006 and the judgment of the court in the following year in the case of Advocaten voor Wereld. The case dealt with a request for a preliminary ruling by the Belgian Constitutional Court and raised some important questions within the context of what back then fell under the EU's third pillar, namely police and judicial cooperation in criminal matters. Advocaten voor Wereld was about Framework Decision 2002-584-JHA, which most of us know as the European Arrest Warrant, and surrender procedures between member states. It covered such important fields and questions as the approximation of national laws and the removal of the need for the verification of double criminality, as well as the validity of such a non-verification. The case involved a request for the annulment of Belgian legislation that implemented the framework decision. The challenge was made on the basis, in part, that the list annexed to the decision identifying offences to which the double criminality principle applied fails to satisfy the conditions of the principle of legality in criminal matters by failing to provide offences having a sufficiently clear and precise legal content. It was argued that the list gave only vague categories of undesirable behaviour. The applicant also argued that the judicial authority, which must decide on the enforcement of a European arrest warrant, would have insufficient information to determine effectively whether the offences for which the person sought was being charged, or in respect of which a penalty has been imposed on him, come within the list. The court held that no argument had been raised which would affect the validity of the framework decision. I now have the pleasure of handing over to Frank Verbruggen, who is a professor of law within the Institute of Criminal Law at the Faculty of Law and Criminology of the KU Leuven in Belgium. He will delve into more details about the importance of the landmark case of Advocaten voor Wereld and also frame it within the wider context of the ongoing discussion about the European arrest warrant and the double criminality rule. I hope that you enjoy the video podcast.
Advocaten voor Wereld is a case from 2007, and at the first instance you would say it's not such a spectacular case. It's a technical matter on what is the proper legal basis for European changes to national laws. But it's one of the first, if not the first, case where a constitutional court, in this case the Belgian Constitutional Court, asked a preliminary ruling from the court in Luxembourg. It started in some way a dialogue that was long due between constitutional courts and the Court of Justice. And not all constitutional courts are eager to ask such questions, but the Belgian one never thought that was a problem. The issue was rather technical. It was the debate on whether Europe, the European Union as it's called now, could abolish the system of extradition between the different member states and replace it by the so-called European arrest and surrender warrant. And this happened all post 9/11. So after the terrible events of 9/11, Europe was under pressure to do something. And they didn't want a real war on terrorism, so they really said we should work with the police, criminal justice system far more efficiently to fight terrorism. And the extradition was seen as too complex, too slow, too often repeating the same things. They say we have to have a simple system. And they used the legal base, a framework decision, which was a so-called third pillar instrument. And that created, in 2002, this European arrest warrant was accepted by all member states, but in Belgium the law was challenged and the Belgian Constitutional Court asked to the court in Luxembourg whether indeed there was a legal basis in European law to make this change or whether a framework decision could be used. The allegation basically was that Europe could change the system, could adjust it, but had gone too far by replacing it. It's, in a matter of speaking, they asked to redecorate the house, and what Europe decided was to tear down the house and build a new one, a different one. And that was beyond bounds. The allegation was they could do that, but then they would have to use a convention, and that would be taken to national parliaments and ratified, and that's more democratic. So one of the lessons from the court's decision, which said, no, there is no problem under union law and framework decisions could be used, is that the court is quite flexible as to instruments or procedures if it leads to more and better integration, if it takes things forward. It's not too rigorous in all its decisions. Sometimes it is perceived as such. And this decision was a new nail in the coffin of the so-called special regime, the third pillar, this exceptional and strongly intergovernmental system for anything related to police, criminal matters, and so on. And the previous one was the so-called environmental crime judgment of 2005. And as such, they paved the way, in a manner of speaking, for the Lisbon Treaty, which kind of normalized criminal law and criminal justice as just another European matter where the normal procedures should be accepted, where European intervention was seen as normal and necessary rather than as exceptional and then strictly limited. Now, the decision is important for another reason, because it's actually the beginning of we could call it a love story. It's when the court met the European arrest warrant. They are still very fond of each other. There's plenty of cases of the court on the European arrest warrant. Actually, the reason is that criminal practitioners, judges, prosecutors, defense lawyers, have been using the arrest warrant and the nebis in idem as the two inroads to European law, the two gateways to Luxembourg. And it brought the court, who is not really full of trained criminal lawyers or practitioners, into contact with all kinds of technical matters of criminal law. For instance, the in absentia judgments in the European arrest warrant produced plenty of cases, plenty of legal debates, quite technical ones for that matter. Some say, well, the court perhaps grew too fond of the arrest warrant and now, because it knows it so well by now, that it sometimes abuses it and uses it also for things it wasn't really meant for. And it's quite remarkable, for instance, that if somebody is traveling in another European country and gets arrested because there's an extradition request from a third country, from the United States or Morocco or Russia, that the court actually counts on the home state of that person issuing an arrest warrant to avoid the extradition to the third state, which is strange because if you haven't done anything, an arrest warrant is impossible. If it's a minor offense, it's more difficult than for a serious offense. So the irony is that people who committed worse crimes would be better off than people who didn't. And it has to do with using the arrest warrants probably for things that it wasn't really conceived for. Also, some criticize the court for insisting too much on impunity, the fight against impunity as a function of the arrest warrant, which might be true if it's about punishment, but if it's still just in the arrest and investigation stage, practitioners are reluctant to use punitive language because of the presumption of innocence. But the idea, and the court is very clear on that, is states should cooperate, states should work together. If it works within a national context, it shouldn't be too different and too complicated to do similar things in a European context. So the EAW really paved the way for what is called then the legal space or the judicial space. The other element which the court encountered in the debate on Advocaten voor de Wereld in that case was on the legality principle, because the other complaint was that there is a list where countries do not check double criminality, so the fact that the behavior is an offense both in the country that issued the warrant and the country that has to execute it. For a long list of crimes, that's no longer checked. And that was an allegation that that might be a violation of legal certainty for citizens and so on. Court kind of dealt with it quickly and said, no, it's not a problem. This is open categories because the actual definition is in the criminal law of the state where you will eventually be put on trial. So you're looking for a problem, but it isn't there. But again, it was the first time they had to deal with double criminality, which is a very fascinating subject. The court stresses very much mutual recognition. We should accept that other states make different choices, but we accept them and we're not going to question them. Of course, for this list of 32 offenses, one of the reasons why it wasn't so sensitive is because Europe has been harmonizing those offenses. They deal with organized crime, terrorism, computer crime, and so on. So indirectly, it stimulated Europe to create harmonization of subjective criminal laws, of criminal behavior being defined at a European rather than at a national level. And I think that's the lesson of Advocaten voor de Wereld. It's the beginning of a new area for the court, which was very well involved in constitutional matters, in commercial matters, but criminal law was always seen as a kind of strange thing, and they didn't really want to interfere too much, only to enforce what was community law, later union law. Now criminal law is just any other matter, and if you're traveling, you're both protected by criminal law, but you also have to respect criminal law wherever you go in Europe. Double criminality, of course, is a difficult issue because it's so much related to sovereignty, and especially in fields where policy differences, historical differences, different sensitivities come into play. Say, national symbols, insulting the flag, insulting the head of state, certain fields where ethical choices have to be made, like euthanasia, abortion, and so on. There, of course, double criminality becomes a very important issue because the freedom to travel allows people to choose the country where they go. And then if their member state or a more reluctant member state would use criminal law against them, of course, the condition of double criminality is an important protection. The problem with the case law of the court so far on this issue is that it doesn't want to complicate matters, it doesn't want to put too many conditions, it's quite reluctant to accept grounds of refusal. So double criminality check for many of the offenses is quite limited, and for the others, the debate is on whether it should be abstract, do they have the behavior in their criminal laws, or that you have to look at the specific case and the specific elements, what exactly happened. In the famous Puigdemont case, a Catalan politician that was arrested in Germany and Spain had issued an arrest warrant, the German court said, well, we looked at all the facts and under German law, if we apply German law, this probably wouldn't be a criminal offense. Where the Spanish argument was, no, you don't have to apply the German law, you just have to check the German code and see whether that would be an offense. And then we checked it, under German law, it is. And the court probably will lean towards the Spanish position, because of course the whole idea about the arrest warrant and not having too many double criminality checks was that we shouldn't have a trial every time somebody gets arrested or a mini trial. We just trust the one who issued the warrant and they will have the trial afterwards. I think one nuance could be brought into the case law of the Court of Justice. The double criminality check perhaps should be concrete, looking at the exact facts, possible justifications, excuses, and so on, if it concerns something that happened on the territory of the requested or the executing state. So if there's a certain offense, like some very national offense, like abortion, which still is strictly regulated in some member states, far less in others, then it does matter where it happened. It seems logical that we might accept more restrictive rules on abortion if it happened in the local system. It would be more controversial, and as far as I'm concerned, not be a wise choice, to accept extraterritorial application. If abortion happened in a place where it was completely legal and justified, that should be accepted too. There, the double criminality would have to be applied in a specific situation. If certain behavior is legal, like gambling, and it happened in a place where the local law was respected, then we should apply the local law, also the justifications under local law, and not just look at the abstract laws. and then apply the most repressive one. So for the Puigdemont case, the Catalan politicians, it might be relevant that the behavior they are being prosecuted for happened completely on Spanish soil. So applying the Belgian law to see whether that behavior was proper or legal or illegal should be on an abstract level. If they had done their actions on Belgian soil, more respect should be due for the Belgian law, and Spain should accept, for instance, justifications like freedom of speech or whatever under Belgian law. And we'll look forward to decisions because there's plenty of cases in which double criminality probably will be raised. So we look forward to the position of the Court of Justice. And accepting it would be mutual recognition, not just in the more punitive, repressive way, but also mutual recognition of choices that states make not to consider certain behavior criminal or to accept that certain persons should be protected against prosecution.